Hey, everybody. Welcome to Startup Basics. It's me, Jason Calacanis, your host. Welcome to the program. This is the program where we're going to go over the most important issues that a startup has to deal with and just do it in a very basic fashion. With me is Todd Carpenter from Wilson Sonsini and Rachel Proffitt. They've both been working with startups for decades. You guys love working with startups. You could work further up the food chain, but you love startups, right?
Yes.
What do you love about working with startups?
It's fun. It really makes our job fun. I mean, we live vicariously through our entrepreneurs, and it really gets you out of bed in the morning. We set up the SOMA office and included in there some. It's not really co-working space, but it's open space for early stage companies to work out of, and it's just so much fun to that energy and to watch guys go through the funding cycle and the ups and downs of being an entrepreneur. It's great.
Awesome. Well, listen, today's topic is an important one. It's what we commonly refer to as IP, intellectual property. There's a lot of pieces to intellectual property, and I think this is something where entrepreneurs hear about it and think they have to protect themselves or don't know. So what is intellectual property for somebody who's a first-time entrepreneur and he or she is just saying, what do I need to do to protect myself and my idea? Should I be having angel investors sign NDAs? Do I need to file patents for my ordering food app? What is intellectual property? What's the purpose of it? Let's just very basically talk about it.
Well, the purpose is protection of ideas, and there's quite a few different types of intellectual property. I mean, the key buckets, you've got patents, trademarks, and copyrights, which are registrable IP, so you can file with U.S. Patent and Trademark Office. And then there's non-registrable IP, so things like trade secrets, and those are protected through confidentiality and your measures to protect them. The key example there is the formula to Coca-Cola, which is not patented, but they keep it secret, and they receive a business benefit because of it, and so through that they get trade secret protection. Right.
And all the employees there sign, hey, I'm not going to take these trade secrets and sell them.
Yep.
So if I start a company, let's just say, a couple of people in the dorm room or, make a little product and we call it Uber and, hey, it's pretty fantastic. And, we've got 3 or 4 cabs there and we're incorporated. And so we've got a business. We raised a little bit of angel funding. What should we start thinking about doing? And what is the expense of this? Because that's, I think, a big part of this is, when do I go through the expense? So if I own Inside.com or Uber.com, do I need to get a trademark or not? And when do I decide to do that?
So I think there's a whole host of considerations when folks, like you say, start developing something interesting and have all these ideas. And part of our job is to counsel sort of the company you're forming should have all the IP related to it, because then investors like yourself will come in and want to invest, and they want to make sure the idea lives not with the individuals around the table, but in that company.
Right.
So part of the initial incorporation process is usually all the founders doing a whole data dump of business plans, any IP they've had, any registered IP they've done, licenses, et cetera, all in. And then on a going forward basis, the company needs a plan in place to make sure that all of the consultants and all the employees and anyone who touches code or has brilliant designs, again, all assigning it to the company.
And that's called IP assignment?
Exactly.
That's an agreement you sign.
Exactly. And you should anyone who touches something about your company in that way, some sort of designer, even sometimes a receptionist are asked to sign these things because you never know what brilliant idea they're going to have, should be assigning it to the company. So literally if the
receptionist says, you know what, I think when you click on the Uber thing, it should tell you how many minutes, you want to make sure that
you own that, right?
That you own that.
Exactly.
So we all sign that when we go work for somebody. Now, this is one thing that happens a lot is people work on a project and there's 3 of us and we're going to start YouTube, or actually Snapchat would be a perfect example where they just worked on it and it was one person's idea according to, and I don't know the state of this, I'm not asking you to talk about that specific case, but in that case we all read there was one person who says it was their idea, the other 2 people were like, yeah, that's a great idea, but we're starting a company and we don't want to work with you. And this idea is kind of trivial and all that kind of stuff. How do people navigate those kind of things where a bunch of people had an idea and were drinking beers and goating on a weekend and then suddenly 2 out of 3 people want to make a business? What's the proper way to do that?
Well, the proper way to do it is what Rachel was describing, and that's kind of what we look at as the baseline for intellectual property is these IP assignments. So whether you're a consultant, an advisor, or an employee, there are separate agreements that every company should have that whenever they're involved with the company, everything is assigned, and the founder should assign everything upon incorporating the company and buying their shares. And hopefully, if you've done all that, then the company owns everything, and it's not an issue. If not, then you
how to
have
put the genie back in the bottle here. So, do I go to the third partner and say, like, listen, I know that you worked this weekend with us iterating, but you want to go work at Google and we want to go do this thing. Will you sign this piece of paper?
And sometimes that costs the company money and or shares, right? I mean, we've had the circumstance where founders come to us and I say, oh, great, so there's the two of you. And they say, yeah, well, and there's this other guy or gal, and he or she helped us with the first iteration, but they've decided to stay at their other job, or they've decided that they don't really want to throw their heart and soul into this startup. What do we do, right? And it just becomes a risk allocation exercise, right? Are you just going to say we're going to do nothing and hope they never knock on our door when we go public for $2 billion? Or do we go to them now and say, here's some cash, or hey, here's a % of the company, and thanks for your time, and hey, can you sign this piece of paper?
It's a bit like insurance, and it makes it a challenging sell, because when we're having that conversation, this is our buddy. It's a friend of mine. Like,
right.
What are they going to do? But then when that buddy sees dollar signs equal to 1/3 of the $2 billion valuation, because we had a handshake deal on this, that will cost you quite a lot of money.
Well, I mean, this is what Zuckerberg went through for many years with, in some cases, people who, there was one person who was fraudulently accusing him of that all got dismissed. But then there were other people who actually worked on it, and he changed entities a couple of times, and I guess it all worked out with settlements, right?
Yeah, so that's how you...
Costly settlements.
Yes, it's much more expensive to deal with in the future. But
even Zuckerberg made this kind of mistake. He should have had it clean from the beginning. Or he did make a mistake in that he wound up getting the lion's share. I guess is how you could look at it, depending.
Yeah,
who knows?
It is. It's risk analysis.
The lawyers won, right? There's a lot of legal fees there in getting that settlement done. So what about trademarking stuff? So if I own Inside.com and the Twitter handle at Inside, do I need to trademark it and worry about that early on or later on? Because that's a couple $1,000s expense. When should I worry about that?
With the caveat that we are not trademark lawyers.
Right.
We usually do recommend an initial counseling with a trademark lawyer to figure that out, because in some instances it's going to be extraordinarily important before you build a whole brand around it, right? Because if you should learn that it's infringing on something else, or it's too similar to another word or another business idea, these are things that it would be great to know before you invest millions.
I see. So if there was somebody doing Inside and it was a news app or a news product and there was going to be a likelihood of confusion, I would have just built a huge PR marketing campaign around a brand that I can't use.
For them, right? Exactly.
For them, right?
Yeah, and I think a lot of it depends on how critical those words or that name or the trademark is to your business. Is it just a random assortment of consonants that you've squashed together? Just because you could get the URL, or is this really critical to what you're doing? And is your company's identity really built around this? If it's the latter, then I think it's much more important to do it earlier, because you're really building a business on the premise that there's going to be value in those words or those letters. And if you lose them 12 months into it, you've got a lot of work to do.
Yeah, and it does. There have been many instances where people inadvertently launch something.
Absolutely.
And realize, my God, there's somebody doing something very similar. Yeah. And I see it happening over and over again because people are doing apps. And they look and they say, oh, there's no app called Inside. Or there's no app called this.
Right.
And then there's somebody who's been doing a website or a CD-ROM before that or something that is exactly analogous to it, and they just didn't even know about it.
Exactly, and that's the problem. It's just how broad of a scope are you looking at when you're doing your own analysis? And sometimes clients are extraordinarily proficient at looking at all the USPTO sites and doing Google searches and, just very exhaustive. And other times they've been very narrow and said, I checked the App Store, there's nothing else there. And so I've built my whole brand around this. And so it could be a good use of money.
When I saw it recently was Facebook came out with a news app, speaking of news app, called Paper. But they called it Facebook Paper. And there's a magazine in New York called Paper Magazine that has an app. And then there was an app that was App of the Year, literally like App of the Year called Paper. Yeah. And I just thought to myself, what is Facebook doing? Because Facebook is suing everybody based on book or using face. And they launch an app called Paper when there's the editor's choice for the year was Paper. Like that is to me like, how does that happen at a big company like that? I mean, people make mistakes.
Risk.
Or calculated risk.
Yeah. I mean, that's a big difference between, and I think this is an important point with respect to what you do with regards to your intellectual property and your strategy and portfolio is you need money to enforce things. So if you have a giant patent portfolio, but you can't enforce it, it's not really all that effective. So I think startups need to be very thoughtful about what they do and how they build their strategy to make sure that it's really going to be protective and it's the best use of their dollars. I mean, is it better to do that or hire another engineer or another salesperson?
And trademarks are one thing because we're talking about low thousands of dollars. But when you start getting into patents, we're talking about tens of thousands of dollars to get them filed and maybe hundreds of thousands of dollars or more to actually, as you're saying, implement them or defend them.
Correct.
Yep.
So, again, I know you're both not patent attorneys, and that's a very specialized thing, but are startups that you see generally today getting involved in patents in terms of filing them, or does that happen like B round, C round, D round? Somebody says like, hey, I want to file a patent on this and this.
I think it really does depend which industry you're in, right?
Yeah.
I mean, definitely there's clients even in really early stages who are filing provisional patents, right? To put a placeholder in there, and then they don't have to think about prosecuting that for at least 12 months, right? And again, maybe more important in a med device or pharma sphere than it is in like the app world, right?
Yeah.
I mean, so just I think it depends. It's industry specific, it's company specific. But you're right. It's a lot of dollars, and sometimes that's better spent getting the right talent to actually do the product design.
And what about when your company gets caught up in one of these patent dragnets? Because I had a company I wanted to invest in, and they were very young, but it was in the dating space. And I guess there's some people who have all these dating patents, and they had this letter, and they were being shaken down. And I was like, you know what? We were talking on another episode about like very easy for a VC or an angel to just like sort of discount or move on to the next investment opportunity when something like this material happens. And I was like, listen, guys, I don't know if you're going to be able to overcome this. What did people do when they get that?
I mean, that's probably one of the biggest risks, I think, to being in the startup world is, to Todd's point, you have to have money to enforce your rights, right? So the best you can do is try to find the middle of the fairway and hopefully execute on a business plan in that way. But unfortunately, the big folks with the big deep pockets can shut startups down if they want to, right? If they've got the intellectual property or even the lawyers who are willing to proceed down that path, because you'll die under a stack of papers before you'll have a chance to get your product out and really defend yourself.
Yeah, I think that's why a lot of folks in this community feel pretty strongly about patent reform and the need for it. Right?
And where are we at with that? I mean, it seems to be that the big companies, we see Elon Musk saying, I'm not going to sue anybody. We'll let you use our patents provided you don't take patent action. Samsung and even Google seem to be cooling down the rhetoric. And then a bunch of other people have sort of made patent arrangements. Do you get the sense that generally we're moving towards reasonable patent usage by tech companies, or is it still a hot button?
I think you're seeing it more from Silicon Valley companies that understand the benefits of working together cooperatively. Right. Twitter announced stuff years ago about this. And so I think companies like that want to work collaboratively in an ecosystem, yes, but there will be competitors from outside the ecosystem or some even within the ecosystem that see it as a big strategic benefit. So I don't think it'll go away. They've got a lot of smart people working on reforms to help prevent it from stifling growth in startups, but I think we've got a long way to go.
We're starting to see actually in the entrepreneurial space, which I found really encouraging, some people saying, I will not back down and I'm going to fight this. And I'm going to raise money, and I'm going to crowdsource some funding. I can't remember the name of one of them.
No, I've heard about these things.
Yeah, and it's actually starting to work, where they won't back down, and they're countersuing, and they're like basically trying to invalidate the patents and find prior art, people who've done the idea before the patent came out, and really negate these. So there's actually some groundswell now amongst the entrepreneurial community to do this.
And sometimes it's always a PR play too, right? Because the big bad patent holders, they don't want their names splashed all over the blogs and on Twitter, right? Being the people who are trying to shut down and hamper our economy, right? Yeah. So it becomes both a political war in that regard and a legal war, right?
And what are they out for? They just out for you to sign a piece of paper and give them a little bit of money and agree that like you...
Depends, yes. It's usually the invitation to license is how these come across, right? So they want something, and it could be equity, it could be cash. In some instances, I've seen it where they're actually looking for a total cease of operations. They don't want you to be competitive.
I think it depends who it is, and I think it's easy to paint anyone that brings a patent suit in a negative light, but there are people that truly are trying to protect their product and their company, and they're doing it for genuine reasons. There are others that own patent portfolios solely for the purpose of suing people and trying to either get a settlement or a license. And there's folks there's people all in between. So I think it really varies depending on who's bringing the case.
Now, what would happen if two people worked on a project together for a couple of months, built it, it was incorporated, whatever, but they just couldn't see eye to eye? Two partners just they go off on their own. And they both decide they're going to make a better version. So they both worked on this social network, and now, they both worked on Friendster, but Susie's going to go make her Friendster 2.0, and Bobby's going to make Friendster 3.0. What happens then in terms of a breakup like that and the company getting shut down and then they go on to do their own thing?
Oftentimes, I think people just go on their way, and as long as you can convince your future investors and employees that there's not overlap, you're not taking intellectual property that was created by the other person, then they just go on their way and build their companies. Sometimes you will have agreements, express agreements that say, I actually just did one with a startup where the two founders split after about a year, and they entered into an agreement that said, we can both use the stuff that was developed in this old company. And you can't sue each other over it, and then that way there are two viable companies, and they'll just compete on the merits rather than one trying to come and bring a claim down the road.
And if in fact there's true technology there, that's what you should do, right? Because for you to leave it in a company, to your point, that probably never is going to get properly shut down.
Right.
and then neither of you have any ability to, say, I own it. Actually, neither of them own it, right? To be able to actually go out and effectively compete and sort of monetize that business, there probably does need to be an agreement between them.
Intellectual property is not a perfect science, and you have to just do the best you can. Is that a good way to look at it? Like, you can't ever be perfectly protected or insulated. You just got to sort of protect yourself as much as your budget allows in a certain extent, and as much as you reasonably can, but you're not going to get 100% protection.
No, but there are the baseline things, the boxes you should check, like we talked about earlier. Like every employee should sign an invention assignment agreement.
Right.
Every contractor, in the consulting agreement, there should be an invention assignment clause. So just the very basics like that, I think you can really create problems for yourself that wouldn't have cost much to avoid.
Yeah, that's really easy, right? I mean, it's just one form that everybody signs as part of their employment package.
Absolutely.
And then if you haven't done it and you've got 10 employees and you give it to everybody to sign and somebody says, I don't want to sign it, what do you do?
You probably need to think long and hard about what that person's doing for the company, right? Because usually, and we inherit clients that haven't had great housekeeping, and we have to put a bunch of retroactive agreements in place and get it all buttoned up. But if there's this holdout, the question is, what is it about, right? Is it because they want to go and commercialize this on their own? Do they want more cash? Do they want more stock? But you probably shouldn't allow this critical engineer to continue to develop your product if he could walk out the door with everything he's doing.
Yeah, you know what I do? I give him the raise, I have him sign it, I fire him.
That's exactly right.
That's it, man. You want to get hardcore with me, man. That would be a pretty good way to do it. But it's pretty simple to have people sign that. Now, what about the people who are moonlighting and doing stuff on the weekend? Because I get this a lot.
Yeah.
In fact, I had dinner last night with somebody who works for one of the top 3 technology companies, who's pretty brilliant. And he said he built what he built, which is pretty impressive, on the nights and weekends on his own computers, and that it was all cool. To which I said, do they know it's cool? So what is... If I invent stuff on the weekends or nights at my house, on my internet connection with my laptop, am I cool?
There's a lot of presumptions about that, and that's probably one of the hottest topics these days because everybody wants to be an entrepreneur now. That's sort of the thing of the day.
Yeah.
And I think a lot of it's going to be extraordinarily dependent on what their agreements with their current employers say. That's, again, part of our day job is founders saying, hey, can you look at this co-founder's existing employment arrangement and see if what he's doing for me is kosher? And there are some agreements, even with the big folks in the Valley, that have expressed, thou shalt not do anything even on your own time, right?
Really?
Right. And
so they can say, you can't on the weekend develop something.
It depends what state you're in, because different states have different employment laws. But California is very employee friendly. So if you're here, you're safer than other places in the country.
But if they pay you a ton of money and give you a bunch of options, and you're in charge of the company, and or you're a senior manager or something, can't they buy out that right or no? Do you think?
You mean in California, could an employer? Well, I mean, there are sort of these provisions that could effectively be read as like non-compete, but I don't know that they can fully buy out your ability to not work nights and weekends. And, the points you made are the ones that are the typical ones to check, right? Where you're on your own equipment, on your own time, not doing anything related to the company. In that instance, you're probably in a pretty good area, at least in California, because again, it's a very pro-employee state.
Yeah.
But you're right to ask those questions. And frankly, founders should be asking that of their co-founders, right? What else have you been doing? And do you have any contractual restrictions against helping me build this company?
Well, these days, saying saying you're not doing anything that's related to what your current employer does is becoming harder and harder.
Exactly.
If you work at Google, that's a tough thing to say.
Yeah, right. They don't even know what's going on at Google X.
Exactly.
Yeah.
They're like, yeah, we're reinventing matter. Sergey Brin is creating a new type of matter, so everything on the planet and in the universe is now part of what Google's plan is. They've reinvented matter. Right, it's true. And then is there not an easier way to do this, which is to be upfront with your current employer and say, hey, I'm doing this on nights and weekends. Can I get you to sign? Is there some kind of agreement?
I mean, sometimes I've seen even just simple email acknowledgments, that's great. I'm happy for you because gone are the days where people stay at companies for even 5 years now, not just 10 or a whole career. So I think we have to be aware of this employee mobility reality. And I think that's usually the best advice, right? Is just to be upfront and allow them to know that here's what I'm going to do, or I'm leaving to go pursue this. And then you sort of hopefully forecloses the nasty letter about, did you walk away with our trade secrets? Are you telling them, all our confidential information? Because you just were upfront and candid with them about it.
Yeah, you were honest about it.
Totally.
And an email, even though it's not a legal document, it's a pretty good thing to have. I mean, if you have an
Written
email
evidence.
from your manager saying, totally cool, Jason, you can work on Insight on the weekends when you're working for Yahoo. We don't have a news mobile product currently. Like, that'd be pretty good.
Yeah.
That would be good.
Yeah, it's a pretty good start.
Well, and I think in the vein of advice like that, we see an awful lot of people that do very silly things, like download their sales client list. Just things that
That's dumb.
these people are in
code,
they're
It's
in the
not
tech
good.
industry, and they should realize that this stuff is all traceable. And if you want to go start your own company, do it on your own. Do it with your own ideas, your own leads. Because all of that stuff is very traceable. So there's ways that you can get yourself in a lot of trouble. Which
This has happened recently where we've had people do a data dump,
Right.
and then go work for another startup. And then the big company sues the medium-sized company, and the medium company does what? They cut those people loose immediately, right? They can't have that liability.
Yeah.
Absolutely.
I mean, and then if you were to do that and start a company, oh my God, would you be starting off on the wrong foot? What's the point, right?
Yeah.
There isn't one.
There is no point. Like, why would you take anything from the current company? Just walk out the door and not. Everything is, you can just start over from scratch.
Yeah, if there's overlap at all in the business that you want to develop, in the business you're currently working on, that's exactly the best advice. Quit, go start your company if you're that passionate about it.
All right. I think everybody gets a pretty good idea of what you have to do here. Do it right. You obviously have to have a decent lawyer who can explain this stuff to you and give you good counsel. And I think those IP assignment things are critical. I mean, I'm going through this all the time with people of like, have we done an IP assignment? Is that also part of term sheets now that the IP assignments get done, or the first round?
It's often a condition of closing on the financing that everyone has signed one of those. So we'll frequently end up doing a little bit of cleanup work just prior to closing. You'll realize, I thought we had them all, but these 2 or 3 folks didn't sign, and we'll get them to sign a retroactive agreement and make sure everything's buttoned up.
Awesome. Well, listen, this has been another amazing episode. God, I'm learning. It's good. I get free advice. I get to refresh my knowledge of all this space. Todd and Rachel, thank you so much. And thanks for Wilson Sonsini. You guys have always supported everything I do. I really do appreciate that, because
Happy to do it.
Yeah,
you know how
welcome.
hard work the team puts into the launch festival and stuff. And, you guys have literally supported me from the beginning, and you continue to do it every year. So that really means a lot to me, and I appreciate it. So, okay, we'll see you all. I'm going to go foot clamped over here. We'll see you next time. This week in Startups and Startups. Bye-bye.